Habib dah breakfast ke? Dah breakfast already.
Okay. So address Puan sebagai macam mana? Puan Shima ke macam mana?
Yeah, you can just call me Shima.
Okay, baik.
Yeah. Encik Habib ada kena-mengena dengan Habib Jules ke?
Unfortunately tak ada lah.
Just kidding.
As we can buy from you, Cik Habib.
Yeah. It's not the first one asking this question.
You know lah, woman. By the way, your slide, your presentation, is it enough for one hour?
Yeah, that's right. Yeah,
Okay.
I'll take about 1 hour.
1 hour. So what about Q&A? How many questions do you expect to take?
Okay, that one I think we leave it first lah to see. We'll try to entertain as many as possible. Then until a certain time, then we'll stop.
Okay. Yeah, for any extra questions, maybe we can email you then.
Yeah, sure.
Yeah. Okay.
That'll be good.
Yeah, sure. Okay, we've got another 8 minutes.
Okay.
All right.
Most of the participants are.
Yes?
Most of the participants from legal department or other departments?
No, it's across the MIDF group itself.
Okay, right.
Yeah, it's just not legal. Our legal is only like group legal only have 3 of us, and we have another legal department which is under investment bank. That is also with 3 staff.
Okay.
Yeah, small ones. Okay, Cik Habib, you ready?
Ready.
Okay, let's go. All right. Assalamualaikum warahmatullahi wabarakatuh. And a very good morning to all warga MIDF. And thank you for joining us on this webinar. Today's webinar is titled sorry. Tak makan lagi kot. Today's webinar is titled Successorship of Borrowing Entities. Who should the financier go after? Before we start the session, we seek cooperation from all participants to mute your mic, but you can leave the camera on if you wish to. Thank you. All right, Group Legal have invited Encik Habib Rahman bin Sini Mohidin, a senior partner from Esri Law, which is one of our panel legal firms. Good morning, Encik Habib. Morning. It is indeed a pleasure to have you in this webinar. A brief introduction on our speaker today. Encik Habib read law at IIUM with 30 years experience as an advocate and solicitor under his belt. He is also a Sharia law practitioner and has served the Sharia Practice Subcommittee of the Penang Bar for many years. With his extensive experience and knowledge, he currently oversees the litigation division of Esri Law. In today's session, Encik Habib will be sharing his knowledge on the debt recovery process. This will include an overview on the administration of estate under either the grant of probate or letters of administrations, and most importantly, the rights of a creditor in debt recovery. Thank you, Encik Habib, for taking the time out of your busy schedule to join this session. Without further ado, I will now pass the floor over to Encik Habib. Encik Habib.
Thank you, Puan Shima, for the introduction. Assalamualaikum warahmatullahi wabarakatuh, and very good morning to the warga MIDF. Okay, first I'd like to express my gratitude for MIDF for giving an opportunity for Esri Law Firm to give or deliver this talk. So I'll take about 1 hour. Just imagine like you are taking a journey from KLIA to Penang for nasi kandar. Just in 1 hour. Okay, as we know, banking sector is vital to Malaysian economy. Banks not a social entity. Its function is to safeguard the deposit or deposit and also share all those interests. As such, it's vital to recover all these outstandings. This talk is organized to highlight the role of successors of a deceased or wound up entities so that you could enforce your recoveries efficiently. Okay, as a starting point, we move to the topic of institution of civil action. Let me take you to the flow chart of when you are instituting a civil action. Okay, basically, when you decided to institute a legal proceeding or litigation process in the civil court, so it will be divided into a certain part as laid down by me in this chart. Firstly, you need to identify the parties you're going to sue. The reason is the law is a person cannot own property or exercise rights or property when he passed away. So that's the reason before you decide or proceed to file a suit, so you need to identify the status of defendant or borrower. The reason is this: let's say you have taken judgment or you have sued a party unknowingly, you already passed away. So the judgment will face the consequences of being set aside for nullity or for irregular judgment. So for that matter, you need to identify the status of a borrower or a business entity before you decide to proceed with the case. So after you identify the parties, then you identify the cause of action. Of course, if you are suing a party who's alive, so the cause of action will be different. So if you are suing a party or representative who have repropriety of estate or person who have passed away, the course of action will be different. So that's the reason it's vital to identify the parties or status of their parties. So the next question will arise is where to check their status of the borrowers or the business entity. Okay, all the records of individual or companies and their status, whether they are alive or they pass away, will be kept in the government department. Okay, if you are looking at or you want to verify about a status of individual, then you need to make a search at Jabatan Pendaftaran Negara or National Registration Department. So all the particulars of an individual will be kept there. So the advantage of making a search is you'll know whether the person is still alive or he passed away. So if he is alive, his current address. So easier for you to institute the case. And on the companies or business entities, so you make a search at the SSM or Suruhanjaya Syarikat Malaysia or Companies Commission of Malaysia, CCM. So both these JPN and SSM will keep the records of individuals or companies. Okay, well, once you obtain the record or the process of obtaining a record from JPN or SSM will involve two parts. First part is if an individual he'll verify or inform you whether he passed away or alive, and for the companies, SSM will inform you whether the company is still in existence or already undang or wind up. So once confirmed, let's say once confirmed an individual already passed away or a company has been wind up, so you move to the second part. Okay, on the second part is before that, number 3. Okay, well, once you confirm, let's say an individual they already passed away, so you need to ascertain from JPN itself. Sorry, you need to entertain or ascertain whether any administrator have been appointed for the deceased, or whether any probate have taken for the deceased, and to identify who is the administrator for the estate. And similarly, for the companies, you need to identify if, let's say, the company has been already wind up, so you need to identify who is the liquidator. Liquidator can be Director General of Insolvency or a private liquidator. So that's the reason you need to identify the status. The administrator or the liquidator will be the successors for the borrowers. Okay. Okay. Before I move to the next slide, I like to just highlight for individual. There is a registry, a centralized registry at the Kuala Lumpur High Court, where they kept all the records of administrators. Let's say a person already passed away, family members applied for letter of administration. So all the records will be kept at a division called Bahagian Kuasa Mati at Kuala Lumpur High Court. So you need to do a search at the department. The payment will be about RM12. Then the department will inform you who is the administrator and the identity and also the address of the administrator. So from there you can move to institute claim against the respective administrators. Okay, now we move to the next slide. Okay, when a person pass away legally, the person has no authority to deal with the property. Okay, let's say a person passed away. Any relation to the person, whether it's a spouse, whether it's related by birth or marriage, spouse, children, parents, are not clothed with authority to deal with the property until an appointment of court, we call until court give them or award them letter administration or probate to them. So without any appointment by the court, how close they are related, they have no authority under the law to act for the estate. Okay. Then you may ask, you may have come across for Muslim, you may have come across sijil faraid, or we call sometimes some court they call perintah faraid. Perintah faraid also have no authority to represent the estate. Faraid, sijil faraid or perintah faraid issued by the Sharia court is only to determine who are the beneficiaries and the portion they are entitled for the deceased property. But to represent the estate, they have no right. So only the civil court have a right to appoint a person to be the administrator. Okay. So yeah, if you look at this slide, it will show you that there are two ways to get an administration. One is if a person leave a will, the court will award them probate. So if there is no will, then the court will give them letter administration. So both have a similar function. Both will carry function as an executor or administrator of the estate. So once a person been appointed through probate or letter administration, so he'll be clothed with authority. So legally that person will be successor for the borrower. Okay, now we look at the estate. When we talk about estate here means the estate of the deceased person. So it includes or comprise of all the properties, whether it's owned or entitled, or sometimes he may inherit after he passed away. Maybe he inherit from his grandfather or parents, but during his lifetime it's not processed. So the estate of the parents or grandfather only been concluded after he's passed away, and he legally is considered he is inheriting the whatever residue from his parents or grandparents lah. So this entitlement or whatever he received also part of his estate. So including any royalties he received after he passed away. And also any debt someone owed to him also is part of the estate, and as a creditor entitled to claim for all the all the remainder of the estates. Okay, the law in Malaysia governing deceased property is through an act of parliament we call Probate Administration Act 1959. So once a person obtain a grant of probate or letter of administration, so he'll be clothed with authority to succeed the deceased. So once the letter of administration is granted to the administrator, he may proceed with the duties of administration of the deceased estate. So now let us look at the duties of the administrator. Okay, once a person been appointed administrator through the court process, okay, main duties are firstly is to collect all the debts due to the estate, and once he collect all the debt, also including properties, bank account, any proceeds, then the administrator duty is to pay all the debts. Through the proceeds, pay all the debts, and the balance only the administrator can distribute to the beneficiaries. And the beneficiaries only entitled for any inheritance after the payment of debt. So their entitlement is contingent on the payment of the debt. Okay, now we move to the other part of my slide. On the payment of debt, of course, the issue arises whose liability to pay for the debt of a deceased. Okay, under the law, personal liability is liable for the debts payable by the deceased. However, the payment of the debt is to come from the deceased estate and not from the administrator's personal belongings or own pocket. If, firstly, the administrator will pay all the debts and is duty to pay the debt. So if, let's say, for a creditor want to recover a debt from the from a deceased person, so you need to institute a claim against an administrator legally appointed by the court. Okay, to highlight this point, I'm just quickly going to refer to a case. Lo Cheng Leong is a High Court case. Okay, firstly, the court says that defendant owe a fiduciary duty to the creditors or any beneficiaries. The fiduciary duty here means to act impartially in good faith. And the court further emphasized the fundamental duty is to pay all the debts of the deceased, and after the payment of debt, then only the administrator can distribute the remaining or the balance to the administrator. Okay, the reason why the administrator we call they are under the fiduciary duty is under the law we call we term them as a trustee. Trustee means they will be administrating the property for the benefit of creditors as well as the beneficiaries. So it means that they recover all the asset of deceased and pay and to settle all the creditors due, and the balance only they pay to the beneficiaries. So in the process they consider them as a trustee. So when the executor act as trustee, the executor cannot benefit from the estate unless he is one of the beneficiaries. Okay, under the law, not necessarily only family members can be the administrator of an estate of a deceased. As long as anyone has an interest in the estate, is eligible to administrate the estate, and the court, in fact, empowered to appoint creditors as administrator where the estate is insolvent. Insolvent means have no assets lah. So under Insolvency Act 1967, even a creditor, bank may petition the court to administrate the estate of the deceased. So the law recognizes the interest of creditor in the borrower's estate. Okay, just to illustrate this point, just to illustrate at this point, if you look at this slide, this decision by High Court, Habib Rahman versus Kepa Chettiar. What happened was a creditor who have lent some money to the deceased have taken the letter of administration. So after he applied for administration and the court appointed him as an administrator, he applied to sell the deceased land for 14,600 to cover or to pay his debt of 33,780 ringgit. So what happened was the deceased children opposed the sale and seek to remove the administrator. The reason is the children will not be benefiting once you paid all the debt. So the court refused, means that the court recognized the role of a creditor to administrate an estate and to pay for the debt. Legally, once letter of administration have been awarded to someone, another party could apply to revoke the letter of administration, but you need to prove either the application, the initial application is defective, or the application was granted through a mode of fraud or through untrue statements. So based on that, the court can remove. But in this case, the court says there is no sufficient cause to remove. The reason is the administrator is sufficiently exercised his right to sell the deceased land to cover the debt. Okay, in order to protect the interests of creditors, the law codified or the mode or the priority of payment from the estate's belongings is divided into two. One is insolvent, means that the estate has sufficient asset to pay the debt, and the second part is if the estate is insolvent, means that he doesn't have the ability or sufficient fund to pay the debt. Okay, but when it comes for solvent estate, the first thing is to pay for the charges for administration, then secondly to pay for the debt, and finally only you distribute to the beneficiaries. So as regards to insolvent, so the priority is given to pay for funeral expenses, administrative expenses. So only if there is a balance, then you pay, or you use any balance to pay for the debts. Okay, under the law, if a person passes away, it doesn't abrogate his right or obligations. Means that the person, even though he passed away, the beneficiaries are still, or the estate is still entitled to honor its obligations. So that's the reason, by consequences, representative must honor all contract entered into by the deceased, including any debt taken by the deceased. Okay, in the process of paying the debt of a deceased, an administrator is empowered also to dispose some of the assets to recover money so that he can pay the debts. So the law allows the administrator to sell some of the properties, but any attempt to sell, you must get the permission from the court. See, the reason why the court permission is necessary is when a person passes away, the court will keep overall supervision on the administration of the asset of the estate. So any attempt or any act by the administrator to sell or dispose the property, so the court consent must be obtained. So once you obtain, administrator can dilute any of the asset to pay the debts of any of the creditors. And the administrator also can mortgage or charge the property belonging to the estate to pay off the debt. The court allow administrator to mortgage or charge the property, but you need to obtain consent from or sanction from the court. So all this, the aim is to promote payment of debt and to settle the creditors debt. Okay, if let's say an administrator distribute the asset to beneficiaries before the creditors, so the law says he'll be rendered himself liable, so he can be sued. The reason why the court imposed the liability on the administrator is we call in legal term the administrator has a fiduciary duty. Okay, fiduciary duty here means to act in the best interest of the estate. He cannot act in the conflict of interest stage. He cannot act in the self-serving interest. You need to act in the good faith or care. So that's the reason the law imposed that the administrator must pay to the creditors first before the other beneficiaries. So if he breach the duty, then he render himself liable. So when I say render himself liable, means whatever losses suffered by the creditors, so the administrator have to bear in his personal, not from the estate, but personally, he'll be liable. Then now we move to the letter of administration granted by the court. Legally, administrator is entitled to act for the estate once the court granted him or the grant of administration. So that's the reason, as I pointed out earlier, we need to make a search to identify whether letter of administration has been granted. So the reason is a creditor only can sue a person who have extracted the letter of administration from the court. Otherwise, you have no capacity to sue or to be sued. So once he obtained a letter of administration from the court, only he's clothed with authority. Then only the creditor can sue him. So the expression of grant involve two processes. Firstly, the court will appoint a person to be the administrator. Then after that, the court will say, give us two guarantors. So after this administrator provide two guarantors, only the court allow the person to extract the grant. So the reason why the court will insist for two guarantors before the issuance of grant to ensure that the administrator will not commit any breach of trust or misadministrate the estate. Okay, there may be a situation, what happened, there may be a situation where the administrator will apply for grant from the court, and after the court allow him to extract the grant, but he will purposely stall or delay in extracting the grant. So in the hope that the limitation period will set in. And there are some circumstances, the family members of deceased delay or refuse to accept a grant. all with the strategy to stall so that limitation period will set in lah. But do not worry, the law do provide relief. Okay, if let's say an estate which have been delayed in applying for letter of administration, the law still allow the estate to be sued. Is provided under Order 15, Rule 6A or Rules of Court 2012. So he's still able to bring an action against the estate of deceased where no grant or probate or administration have been made on the person. Okay, the reason why the court allow a claim against an estate without the probate or administration be granted is to overcome the difficulty of suing the estate of a person. So the law allow you can identify any of the members of the deceased to appoint we call wakil diri or wakil litigasi, and you can sue the person on behalf of the estate. If let's say you cannot identify any of person, there is no family member, you can name or cite Amanaraya Berhad as administrator or to represent the estate and proceed with the claim. Okay, the earlier I was talking on the letter of administration and also grant of probate. It's involved individual. Individual also in a part connected to partnership, because partnership in Malaysia is the law is there is no separation between your partnership asset and or your personal asset, as opposed to company. Company, the company asset is considered distinct or separate entity from the shareholders. Okay, when we say a company liquidation, or sometimes we use the term insolvency. Okay, insolvency term now we are using is a collective term to refer either an individual persons or company's inability to pay. While if a company or individual inability to pay, so we say is under insolvency. Okay, general insolvency is a general term that refer to both personal bankruptcies. It's a personal or individual bankrupt or a company in liquidation. So both you can use the term insolvency. Okay, once a company is in liquidation, the control of the company shift to liquidator. Means that it changed from the power of directors to the liquidator. A liquidator of the company can be a director general of insolvency, a government department, or a private individuals. There is we call a schedule, fourth schedule in Company Act, where they provide a list of private liquidators. Basically, they are professionals, either lawyers or accountants. They are also qualified to be a liquidator. So in Malaysia, they could be a director general of insolvency to be a liquidator, or a private liquidator. So the whole idea of insolvency is to preserve the insolvency estate to allow equitable distribution to the creditors. Okay. Okay. Now we look at the duties of liquidator. Okay, liquidator duty primarily to acquire possession of assets, or then to raise fund to pay claim or debt. So it means that liquidator also empowered to sell any or dispose any of the assets to pay the debt. Then once he recovered, then he can distribute the proceeds of sale to the creditors, and if there is an excess amount, to shareholders. And finally, once everything settled, then the liquidator can delist or close the company with the SSM. And primarily, the liquidator's responsibility is to preserve the asset and to settle the issues between the company and the creditors. Okay, before you can proceed with the insolvency or any action, so you must prove there is a debt owed by the individual or company. Okay, let's say if a company have been winded up, a company have been wounded up, a creditor can pursue the claim against company already been winded up. By firstly, you have two options. One, filing a case against the company through by obtaining a leave from the Director General of Insolvency. You can pursue a case. Or second option is to file for proof of debt. You can file if you have a debt against the company. So you have an option to file a case against the company or to file a proof of debt. Okay, if let's say if the debt cannot be ascertained, so you need the court to assess the amount. So you apply the first option. You file a case. After you obtain judgment, you ask the court to assess the amount. So, but if let's say the amount can be ascertained, so you exercise your right under the second option by filing proof of debt. Okay, proof of debt need to be substantiated with evidences. Otherwise, liquidator is empowered to reject the proof of debt. But if let's say liquidator have rejected or reject the proof of debt, you still have an option or right to challenge the decision in court. Okay, now we look at this slide on the who's the debtor. Okay, if let's say you want to proceed bankruptcy against a debtor in Malaysia, you need to show that this debtor is domiciled in Malaysia. Domiciled in Malaysia. If he is staying in a foreign country, you can't exercise this right. But the court have taken a very liberal interpretation on the domicile. If a person is a Malaysian citizen but is still living in overseas, he has business in overseas, but he's been coming to Malaysia to renew his passport, the court have considered this person as being domiciled in Malaysia. So you still can take an action. So as long as there's some relation to Malaysia, if you've been coming to renew his passport, is sufficient to consider he's a debtor. Okay, once a person been declared as bankrupt, the cause of action shifted and vested with the Director General of Insolvency. So if you are going to take any action against a debtor who are bankrupt, so you need to get leave from the Director General of Insolvency to proceed. So the reason why the court or you need leave from the Director General of Insolvency is once a person been declared bankrupt, the ability for him to act on his own is curtailed, and the property vested in the debtor is now vested in the Director General of Insolvency, who become the manager and trustee or trustee for all the property of the bankrupt. So that's the reason why the law imposed before you pursue any suit against the debtor who have been already declared bankrupt, to get leave or sanction from the Director General of Insolvency. Okay, now we look into the another aspect of creditors. Who are the creditors? Basically, in Malaysia, there's three types of creditors. The first creditors is the first one we call creditors without security. The creditor have given a debt without any security. The second creditor, what we know is creditor with security. Means that when the creditor disburse the payment is based on mortgage or charge or lien over the property of debtor as a security for the debt. They have different consequences as a creditor with the security. You can deal with the property charged to you irrespective of the bankruptcy. The law says the asset which have been used as security for a debt does not form the part of the asset or bankrupt. Means that the asset which is under a charge does not vest into the Director General of Insolvency. So you can deal with the charged property. Okay, now coming back to the earlier issue of proof of debt. Okay, let's say as a creditor with security, and also you need to file for proof of debt. So you have three options. Let's say your debtor already declared bankrupt, and you have a security or a property as a security for your debt. So you have three options you can exercise. Okay, first you can use the security or the charged property to realize your debt. The second option is you can value the property, the security property, and you can claim the balance through the process proof of debt. And the third option is you can surrender the property to the liquidator, and you claim yourself as a creditor without security. So you still have three options. So either you can use this charged property to pay your debt, or secondly, you can use the charged property to pay your debt, and the balance you can still claim through proof of debt. And the third option is you surrender the property to the liquidator. The option is yours. Okay, the next or the third category of creditors is we call preferential creditors. It's normally for governments lah. It's involved land taxes, income taxes. So of course, all the income tax is given priority, and also wages or compensation of workers. Maybe you have seen the recent Perwaja Steel cases. Okay, even though they are considered preferential creditors, but they only have priority over creditors without security. They have no preference over creditors with security. So creditor with security or property as charged still will take preference or priority over preferential creditors. Okay, there may be instances where after you pursue a case, maybe when you file a case or file a bankruptcy, the debtor was alive. but suddenly after you file the case, after a certain period, in the midst of trial, he passed away. So the law is debt of debtor has no bearing on the pending bankruptcy proceedings. You still can proceed to declare the person as a bankrupt, as long as at the initial stage of filing the bankruptcy, he was alive and the proceedings or documented have been served on him. Okay, now we look briefly on the partnership. Partnership. Okay, a partner who retires from a partnership still liable for the debt incurred before his retirement. Okay, and every partnership is dissolved with the death or bankruptcy of partner. The estate of a deceased still liable for the debt of partner or individual person for all the debt incurred before he passed away. The estate is only not liable for the debt incurred after his death. So under Insolvency Act, it's still a partnership, still subject to Insolvency Act 1967, means that a creditor can exercise the right under the insolvency to take action against partners in the partnership. Okay, under the law, a creditor with judgment can proceed against any of the members of the partnership. You have the option, the rights given to you. So the reason is this: partnership is we call under law is jointly and severally liable, which means that they are equally liable. Means that if let's say two or more person promise to pay the debt, then the creditor has an option or right to compel anyone to perform the promise. And each partner liable for the whole amount. Even if let's say one partner pass away, the creditor could sue the other partners. So that's the reason. If let's say a partner been declared, let's say a creditor exercise the option to sue only one partner and declare him bankrupt. So if let's say the partner been discharged later, the creditor still has an option to go against the other partners of the partnership. Okay, now we move to Order 15, Rule 7 of Rules of Court 2012. This basically to illustrate, if let's say a pending suit means that you already sued a person in court, you have to check his status, he was alive. So during the process of the suit, suddenly he passed away, or debtor been declared bankrupt, or let's say a company who owe money suddenly have been taken over by another party. The court, the law doesn't extinguish your cause of action, means that you still can pursue against this estate or the companies who have taken over the interest of the debtor. So normally what we do is we'll substitute the party and proceed the claim. Okay, finally, before I end my session, we just quickly look at few cases or decided cases to highlight some of the points I illustrate just now. Firstly, this case it's not talking about successor for debtor, but successor of creditors. For example, if institution who have given the facilities to the customers, then if this bank or institution have amalgamated or taken over by the other institution, the law is once you vested the interest through the law, you still can pursue the charge action without substituting or naming a new entity. This will illustrate a point on successor of creditors. Okay, this case is interesting in the sense that to illustrate that defrauding of by anyone or any beneficiaries to defeat the interest of creditors will be set aside by the court. So what happened in this case is the husband was declared bankrupt. But before he was declared bankrupt, 2 years before that, he transferred a piece of property to his wife lah. Then he passed away. So the court cancelled the transaction because the court find there's some evidence of attempt to defraud the creditors or to defeat the interest of the creditors. So so this case highlight that the court will always assist the creditors so that any properties belonging to the estate is available to protect interest of the creditors. Okay, this case, Islamic Bank Berhad, Urusan Land Sedang Berhad, illustrate position of guarantors won't affect or will not affect the indebtedness or status of a debtor. In this case, what happened was the facility was given to the debtor, and there is a third party was a guarantor, but the guarantor was wind up before that. Even though the guarantor was not party to this action, the court still allowed to enforce the right against the defendant as a debtor. It means that any demise or status or winding up of a company will not affect the surviving parties. Similarly, this case also illustrates the same thing. This way, this case the other way around. The debtor was wounded up, but the respondent was still made liable as a guarantor. The other way around. Okay, this just to illustrate on the Insolvency Act. If let's say a creditor have a security, a charge, mortgage, then after the creditor dispose the security, but the proceed is still not sufficient to cover the balance, you still can pursue for the balance against the individual or against the company. Just to illustrate that point. And similarly, this case also illustrates the earlier point that the guarantor will still liable for a borrower, even though the borrower has been winded up. And this case, this case to Simpang Maju Enterprise near Berhad. What happened in this case is the deceased enter a sale and purchase agreement with the developer. So and taken a loan from banking. So before the money release, the developer have transferred the title to the borrower. But after the transfer, so deceased passed away. So what happened was, once the deceased passed away, the bank cancelled the loan. So here you end up the name of the deceased have been registered as an owner without the developer getting the money from the bank. So what happened was the developer sued the purchaser or the deceased for the money, and the deceased sued the bank institution for indemnity for the money in or money not released. So the court held that the bank indeed have a right to cancel the banking facility once a borrower passes away. Okay, with that I end my session. Thank you.
Thank you very much, Cik Habib. Okay, before wrapping up our webinar, we will once again thank Cik Habib for leading today's talk on the debt recovery process in the event a borrower passes on and in the case of a company in liquidation. We hope that you have learned something valuable today and have a clearer picture on the processes. We would like to open the floor for any questions now. Anyone with questions, please unmute your mic and address them to Encik Habib.
Assalamualaikum.
Assalamualaikum.
This is Amza. I have one question for you, Dr. Encik Habib. In the event where the creditors believe that the administrator did not sell the estate, this is in the event of liquidation. In the event the creditors believe that the administrator sold the estate below market price, and they want to contest that on court, how is this resolved? That's my only question. Yes, thank you.
Okay, thank you, Encik Hamzah, for the question. Okay, basically, if an administrator want to dispose property, the administrator have to file an application to High Court to get sanction before they dispose the property. So in the process of sanction, the court will look into two things. Court will see whether all the beneficiaries consent to the sale. Secondly, the court also will see whether the amount is reasonable. Okay, so at the time, I afraid as a creditor, you have no role over this application, because the proceeding will involve basically the administrator and the beneficiaries and the court. So the creditors will not be notified. So the court is basically is trial by pleading. The affidavit will show the SPA, sale and purchase agreement. Maybe there could be some evidence of valuation report. Then the court will see the consent by the beneficiaries. So if everything is sufficient, the court normally will give the consent to sell. So the creditors, I afraid, have no say over this sale. So only option for the creditors is, let's say the amount is not sufficient to pay your debt, so you only can recover later as a separate proceedings. It means that until your debt is being paid, the beneficiary also will not get anything.
Thank you, Dr. Habib.
Thank you, Cik.
Yeah, Encik Habib, I have one question from you. I'm Sally. Thanks for the law and the knowledge sharing today. Appreciate. I got one question for you. Is that the for company going into, let's say, liquidation, right? They normally we heard that the liquidator will be appointed. So actually, can the company, instead of going through the liquidator, they charge the fees, and then it's even more burden to the company which is in bleeding. Can the company actually go to Jabatan Insolvency Malaysia and actually try to sort out the matter with the creditors, of course, with the creditors? Can that be done, Encik Habib?
Okay.
Thanks.
Okay. Okay. Thank you, Ms. Ching. Okay. For the question. Okay. Okay. There are two types of liquidation. Either we call voluntary liquidation or through the process of court. So, but if let's say through court, so if there will be an appointment of liquidator, either Director General of Liquidator or private liquidator, I'm afraid the director's power is very, very limited or curtailed. So once the liquidator been appointed, the responsibility and the power of the directors shifted to the liquidator. So the liquidator will take over the management and have a say. So the liquidator will convene the creditors meeting. So from there, during the meeting, then the company can propose settlement. But if let's say you want to bypass the liquidator, it's very difficult. You know, the only option is for you to wait for the creditors meeting and propose settlement there.
With this intervention.
Yeah, Encik Habib.
Yes.
Maybe one more question, one last question,
Yes.
maybe
Yeah,
from the floor.
thank you, Encik Habib, for the answer. Thank you.
Thank you, Ms.
Okay. Yeah, anyone else with question? Okay. If there is no more question, we will be adjourning here. Please note that the webinar will be made available for rewatching as it is recorded. We, on behalf of Group Legal, would like to thank Encik Habib and would like to thank all of you who attended this webinar today. Inshallah, we will meet again together. We'll meet again in our next legal webinar. Thank you so much and Assalamualaikum. Bye. Thank you, Encik Habib.
Thank you, MIDF.
Thank you, everyone. Thank you very much.
Thank you.
Thank you. Appreciate
Thank you,
it.
Prima.
Thank you. Bye.
Thank you. Thanks a lot, Encik Habib.
Thank you. Thank you.
Thank you. Take care. Bye-bye. Very good sharing.
Thank you so much. Big applause to Encik Habib and Ezri Law.
Thank you very much.
Okay. All right, Encik Habib, that's it now.
Bye.
Thank you so much. Yeah. Okay, bye.